What happens if you are arrested for a felony in Tucson or Pima County? A law enforcement officer will typically book the accused person into the Pima County jail if they have probable cause for a felony. Then that person will see the judge either first thing in the morning at 9 a.m. or at the very end of the day at 7 p.m. During that hearing, the only thing that happens is the defendant pleads not guilty and the judge sets release conditions and gives them a preliminary hearing date. As far as release conditions are concerned, a person can either be released on their own recognizance, on their promise that they will appear in court. They might be released to the supervision of pretrial services, which is a monitoring agency that makes sure you know about your court dates. They might have you do drug testing or other requirements. Or the judge could possibly set a bond that is cash or secured that you or a loved one would have to post in order for you to be released from jail. In addition to setting release conditions, the court will also set a preliminary hearing date, which is within about 2 weeks of when you are arrested, depending on whether you remain in custody or whether you are released by the judge at your initial appearance. What's important to know is that the preliminary hearing in Pima County is pretty much just a placeholder. They used to do preliminary hearings more in domestic violence cases where they had a alleged victim who they may be concerned may change their story, and they want to get that victim testifying under oath about what happened early while the event is still fresh and while they're still angry about it. I would say since the shutdowns in the pandemic, I have not seen preliminary hearings happen at all. So that preliminary hearing is a placeholder. It is a deadline for the prosecutor to decide what to do with your case. So what's happening behind the scenes in that time period from your initial appearance and the preliminary hearing date is that the law enforcement officer or detective or their supervisors will be taking the information that they have about the accused person and the allegations in the case to an attorney at the Pima County Attorney's Office, typically, although there are other prosecuting agencies in town. And that attorney will evaluate the case with the law enforcement officer and determine whether or not they want to bring felony charges. If they say, yeah, we're ready, we have enough evidence, we believe there's probable cause, then the prosecutor and that police officer are going to go in front of the grand jury to try to secure an indictment. So they present the facts that they have in a proceeding where the defendant and the defense attorney are not present. They tell the grand jury, this is what we've got, and the grand jury decides whether or not to hold a person over for felony charges or indict them. From there, if there is an indictment, which if the county attorney takes the case to the grand jury, the saying goes, the grand jury will indict a ham sandwich. So if it goes to the grand jury, it's very likely that the accused person will be indicted, although there are ways to challenge the grand jury and the fairness of those proceedings later. And then the defendant will get a new court date. That preliminary hearing date will go away and they will be told, okay, you need to show up at Superior Court on such and such date at 1:30 for your arraignment. And the arraignment is when you plead not guilty officially, and the court assigns you to a trial judge, and then the case really gets rolling. Within a few days after that arraignment, your defense attorney will get your police reports or preliminary reports so that you can start exploring your options, understanding what the potential penalties and what the strengths of the evidence are, and then the case goes on from there, which we can talk about in another video, but that's kind of like what happens when you are arrested for a felony up until the arraignment.